Welcome to the HOTMA Income and Assets Training Series, Implementation of Section 103, Over Income Limits for Public Housing Families webinar. HOTMA stands for the Housing Opportunity Through Modernization Act of 2016. This statute made several changes to HUD's rental assistance programs, including changes to rules for income determination and program eligibility for the Housing Choice Voucher and public housing programs, among other HUD-assisted programs. This series is meant to support public housing agencies in implementing rule changes related to public housing families' income and assets. This first training focuses on the implementation of HOTMA Section 103, which creates new income limitations and related procedures for public housing families who become over income after admission. My name is Phil Stump-Kennedy, and I am a part of a team of HUD technical assistance providers from NALCAB, the National Association of Latino Community Asset Builders.
And my name is Farah Fawcett, and I'm also with the NALCAB team. We have been working with HUD to create this training series. HUD staff from the Office of Public Housing and Voucher Programs will be available for questions at the end of the training. And now, for a few more words of welcome, I'm going to hand it over to Kimmy and Ray from HUD.
Hi, good afternoon or morning, depending on where you are in the country. And again, welcome. Thank you so much for spending a little time with us today to discuss implementation of Section 103 of HOTMA. My name is Kimmy and Ray. I am Director of the Public Housing Management and Occupancy Division within the Office of Public Housing and Voucher Programs here at HUD. I have the privilege of working with and supporting a fantastic team of dedicated and talented individuals who have worked, some of them for years, to draft and redraft the final rule for sections 102, 103, and 104 of HOTMA, and who continue to work to further support implementation of the new rule, which was published February 14th. So we are here, we are available, we'll be providing more guidance throughout the year. So continue to look out for more training and support opportunities. There is a lot more to come, I assure you. But today, our focus is on the new rules provisions for continued tenancy of over-income families. And so I have to recognize the fantastic, fabulous, amazing work of Bernita James from my team on the rule, on this webinar in partnership with NALCAB, and on further guidance to come. She is our resident subject matter expert. She'll be available during the Q&A. Following today's presentation. And so I know you're probably anxious to get into some details, so I won't delay us any longer, but again, welcome and thank you for joining us. So Phil, back to you.
There are 3 trainings in this series related to new rules required by HOTMA. There are also related fact sheets and products available on the HUD Exchange. This first training covers Section 103, Over Income Public Housing Families. 2 more trainings will follow covering HOTMA Section 102 and 104, which primarily relate to income calculations and reviews, including assets and asset limitations. Recordings of the trainings and related resources, including a fact sheet and sample notices, will be available on the HUD Exchange.
This training will cover the following topics: overview of over-income or OI rules, related definitions, the process for calculating if a family is over income, the notification process for over income families, policies and procedures related to the termination of participation for an over income family, alternative non-public housing rent, non-public housing over income leases, PHA policies and reporting. We will then review some frequently asked questions and answers, and lastly, we will have time for your questions and answers.
Section 103 of HOTMA creates new limitations on tenancy and program participation for formerly income-eligible families residing in public housing with incomes over the newly created over-income limit. PHAs must implement Section 103 through written policies, and if implementation of this provision requires a significant amendment to the PHA's plan, the PHA is required to complete the significant amendment process to effectuate the policy change. The goal of this training is to assist PHAs in implementing the rule changes in a timely and effective manner and provide clarity on exactly how a PHA is to determine that a family is over income.
Regulations. HUD has implemented the over-income provisions by creating two new sections in the public housing regulations. 24 CFR Part 960-507, families exceeding the income limit, and 24 CFR Part 960-509, lease requirements for non-public housing over income families. Conforming changes to other sections have been made as needed. For example, public housing program lease requirements have been updated to provide that a lease will convert to a month-to-month term in the period before tenancy termination, and to note that being over the new income limit as grounds for termination.
The new rule creates the following definitions. We'll go into each one in more detail later. The over-income limit. This limit is set by multiplying the very low income level for the applicable area by a factor of 2.4. The limit is also equal to 120% of the area median income, or AMI. Over-income family. A family whose annual income exceeds the over-income limit. This term includes families during the grace period or before termination who are still public housing program participants. This is a change. In the public housing program, this term previously referred to a family with an income exceeding 80% of the AMI. Non-public housing over income, or NPHOI family. A family whose income exceeds the over income limit for 24 consecutive months and remains in a public housing unit paying the alternative non-public housing rent.
The income limitation. The rule creates a limitation on tenancy for assisted families in the public housing program who remain over income for 24 consecutive months. This 24 consecutive month period is referred to as the grace period. Once a family is first identified as over income in a regular or interim income examination, they must do re-examinations annually to determine if they remain over income. Families paying a flat rent, who may normally have an income re-examination once every 3 years, would instead move to an annual schedule. The rule provides a 24-month grace period. After the 24-month grace period, PHA policies may allow over-income families to continue to live in a public housing unit paying an alternative rent. If the PHA does not adopt such a policy, the PHA must terminate tenancy of the over-income family within 6 months of the final notification that the family has been over income for 24 consecutive months.
Families who remain in a public housing unit must sign a new non-public housing lease and are no longer public housing program participants. These non-public housing over income, or NPHOI families, may not participate in public housing resident councils, participate in programs for low income or public housing participants, or receive assistance such as utility allowances from the PHA. Further, NPHOI families are not required to comply with community service and self-sufficiency requirements.
Process for calculating if a family is over income. Over income procedures are triggered by annual or interim re-examinations. During the re-examination, if the family is determined to be over income, the over income notification process begins. See the appendix of the supplemental guidance for implementation of Section 103 notice, which will be published shortly, for directions on determining if a family is over income.
We'll now walk through this process of calculating the over income limit. Step 1, go to the HUD user datasets for income limits at huduser.gov/portal/datasets./il.html. Once there, click the income limits IL documentation button. That's the brown button right here. Step 2, select a state. Scroll down the list on the left and select the applicable state. Once a state is selected, a list of counties will appear on the right. I'm going to select Ohio. Step 3, select a county. Scroll down the list on the right and select the applicable county and then the View County Calculations button. I'm going to select Summit County, which includes Akron. I could have also gotten here by selecting Akron under the HUD Metropolitan Fair Market Rent Income Limits Area, HMFA, and choosing Akron down below. Step 4, view appropriate very low income limit based on the applicable number of people in a family. As you can see, that's the top row here. If you are wondering about the process of arriving at that number, you can click on the Click for More Detail button. There is one for each income limit category that will explain what, if any, adjustments were made and the methodology for adjusting income limits. Step 5, multiply the appropriate VLI amount by 2.4. So in this case, if there are 4 people in the family, we would multiply 41,000 by 2.4 and arrive at the over income limit of $98,400. The final over income limit should then be compared to the family's annual income. Please note that the over income limit is based on the family's income and not their adjusted income. This is a significant change from the guidance given in Notice 2019-11. This change must be implemented for any annual or income examinations following March 16, 2023. PHAs that require additional time to make a significant amendment to the PHA plan may delay the change up to June 14, 2023. HUD updates the income limits annually. PHAs must update their over income limits for the public housing program in their ACOPs no later than 60 days after HUD publishes new income limits each year.
Regardless of adjustments made to the very low income amounts, consult that table for the appropriate family size and multiply by 2.4. We could now go back and take Los Angeles as an example, where there is a high housing cost adjustment. That has been factored into the VLI. In other locations, there may be a ceiling adjustment, which has also been factored in. In Los Angeles, the very low income limit is $59,550 for a family of 4. Multiplying that by 2.4, we find that if a family of 4 earns over $142,920, they will be considered over income and the notification process must begin.
Over income families. During the 24 consecutive month grace period and in the period before their tenancy is terminated or they execute the NPHY lease, a family will continue to be a public housing program participant. The family will continue to pay their current rent choice of income-based or flat rent or the prorated rent for mixed families, follow all program requirements, including the community service activities or self-sufficiency work activities requirements, and maintain all rights as a public housing program participant, including requesting an interim income examination.
The process for falling below over income limit. If it is determined in an interim or regular reexamination that a family's income has fallen below the over income limit at any time during the 24 consecutive month grace period, the family status as a public housing program participant remains unchanged, and the PHA can return to regular income reexamination periods for the family. In the event that the family becomes over income again, the family would be entitled to a new 24 consecutive month grace period.
Notices. PHAs must give over income families adequate notice of their change in status. The final rule requires a total of 3 notices. Each one is provided after an income examination that determines that the family is over income. The first notice is at the initial determination of over income status. The second notice follows at the income reexamination at the conclusion of the first 12 months of the grace period. And the third notice is at the conclusion of the 24-month grace period. All notices must be provided in writing and state the actions that will be taken as required under the PHA's over income policy in the ACOP, and if applicable, the notice must include the alternative rent amount. Sample notices are provided on HUD Exchange as part of this training series.
Accessibility. All notices and communications must be provided in a manner that is effective for people with hearing, visual, and other disabilities. The following are examples of accommodations that may be provided free upon request. Accommodations for vision impairments may include brailled materials, large print, or audio materials. Accommodations for hearing impairments may include sign language or other interpretation, auxiliary aids, transcription services, and accessible electronic communications.
The initial notification. When a PHA determines that a family is over income through an annual or interim exam, then the PHA must notify the family in writing of their over income status within 30 days of the income examination. The notice must state that the family has exceeded the over income limit and that continuing to exceed this limit for a total of 24 consecutive months will result in the PHA following its continued occupancy policy for over income families. The notice will explain the PHA's policy of either tenancy termination or the option of paying the alternative rent as an NPHOI family. The PHA must afford the family an opportunity for a grievance hearing if the family disputes within a reasonable time the PHA's determination that the family has exceeded the over income limit.
After 12 months, the second notice, the PHA must conduct an income examination 12 months after the initial over income determination, unless the PHA already determined that the family's income fell below the over income limit during an interim reexamination. So even if the over income status was initially determined at an interim examination, a reexamination would have been scheduled for 12 months later. If the PHA determines that the family continues to exceed the over income limit, the PHA must provide a second notice within 30 days of the examination. This second notice informs the family that they have been over income for 12 consecutive months. And if the family continues to be over income for another 12 consecutive months, the PHA will follow its policy of either tenancy termination or alternative rent as an NPHOI family.
Second notice provisions. The notice must also include the estimated alternative rent, as in based on current data, if the PHA's over income policy permits NPHOI families to remain in a public housing unit paying the alternative rent. The PHA must afford the family an opportunity for a grievance hearing if the family disputes within a reasonable time the PHA's determination that the family has exceeded the over income limit.
After 24 months, the third notice, the PHA must conduct an income examination 24 months after the initial over income determination, unless the PHA already determined the family's income fell below the over income limit. If the PHA determines the family has exceeded the over income limit for 24 consecutive months, then the PHA must provide written notification of this 24-month over income determination within 30 days of the examination.
Third notice provisions. The third notice must inform the family of the over income determination. Depending on the PHA's continued occupancy policy for over income families, the notice must include detailed information on tenancy termination or alternative rent. In the case of tenancy termination, the notice must inform the family of this determination and state the period of time before tenancy termination, which cannot exceed 6 months. In the case of alternative rent, the notice must state that in order to remain in a public housing unit, the family must pay the alternative rent, the amount of the alternative rent, and the family must be provided a new NPHOI lease, which they must sign within 60 days, or at the next lease renewal, whichever comes first. Again, the PHA must afford the family an opportunity for a grievance hearing if the family disputes within a reasonable time the PHA's determination that the family has exceeded the over income limit.
Termination of tenancy. If the PHA policy requires termination, termination must occur no more than 6 months after the third notice, as determined by the PHA's continued occupancy policy. The PHA must give appropriate notice of lease tenancy termination, notice to vacate, in accordance with state and local laws. Families are still public housing program participants until tenancy is terminated in the timeframe established by the PHA, that is up to 6 months. The PHA must continue to charge the family their choice of public housing rent, income-based, flat, or prorated rent for mixed families during the period prior to termination. During the time before termination, the family may request an interim reexamination, which the PHA must conduct as otherwise required by their policies. Reexamination during this period can reduce rent burden during the period up to termination. However, reexamination after the third notice cannot allow the family to remain in the public housing program beyond this period of up to 6 months.
If PHA policy allows for continued occupancy for an NPHOI family, then a new NPHOI lease must be executed no later than 60 days after the third notification or at the next lease renewal, whichever is sooner. If the NPHOI lease is not executed on time, the PHA must terminate the tenancy within 6 months of the third notice. Because over-income families may decline to stay as NPHOI tenants paying alternative rent, the PHA must also have a termination policy. PHA policy may permit an over-income family to execute the lease after the deadline, but before termination of tenancy, if the over-income family pays the PHA the total difference between the alternative rent and their public housing rent, dating back to the deadline. Over-income family members will continue to be public housing program participants until their tenancy is terminated or they execute the NPHOI lease. After the NPHOI lease is signed, the family is charged the alternative non-public housing rent, and family members are not public housing program participants.
Alternative non-public housing rent. A remaining NPHOI family must be charged monthly rent equal to the higher of the applicable fair market rent or the amount of the monthly subsidy provided for the unit. The amount of the monthly subsidy provided for the unit is determined by adding the per unit assistance provided to a public housing property as calculated through the applicable formulas for the Public Housing Capital Fund and Public Housing Operating Fund. Because these amounts vary by allocation, HUD will publish the specific amounts annually. They can be found on the HUD website on the HOTMA Updates for Public Housing page. PHAs do not have discretion when it comes to the rent for NPHOI families. If PHA policy allows an NPHOI family to remain in the unit and pay the alternative non-public housing rent, the PHA will no longer receive the subsidy for that unit. The PHA must not conduct an annual reexamination of family income of an NPHOI family.
NPHOI lease requirements. NPHOI leases must follow regulations at 24 CFR Part 960.509, which heavily borrow from existing regulations at 24 CFR Part 966.4, but with adjustments to account for the families no longer being public housing program participants. PHAs must continue to comply with federal non-discrimination requirements, including the Fair Housing Act, Title VI of the Civil Rights Act, Section 504, and Title II of the Americans with Disabilities Act. PHAs continue to have a legal obligation to provide for reasonable accommodations for individuals with disabilities, including related to unit transfers.
NPHOI lease provisions. Leases must include provisions found in 24 CFR Part 960.509B, such as lease term and renewal. Unlike public housing leases, a 12-month lease term is not required. PHAs may choose to offer NPHOI families leases on a month-to-month basis. Costs covered by the lease, procedures around lease termination and grievances. The lease may include hearing or grievance procedures and may explain when the procedures are available to the family. However, it should be noted that hearing or grievance procedures for NPHOI families are at the discretion of the PHA. Procedures for lease renewal and modification. Upon expiration of the lease term, the lease shall not automatically renew. See the NPHOI sample lease, which includes all of the required provisions.
Waitlist preference for NPHOI families. PHAs may choose to adopt a waitlist preference for the NPHOI families who again become income eligible and are otherwise eligible for readmission to the public housing program. These families would then reapply. Over-income families who have vacated public housing units are not eligible for this waitlist preference. So this policy would only be adopted by PHAs who have a policy to allow NPHOI families to remain paying alternative rent and would only apply to those families who elected to remain at the property. Adoption of this preference is at the discretion of the PHA. Families that do vacate can reapply if they again become income eligible, just like any other eligible family.
The provisions implementing Section 103 will be effective on March 16, 2023, which is 30 days after the publication of the final rule. Once the rule is effective, PHAs should begin to implement their over-income policy after revising their ACOP per 24 CFR Part 903, if a significant amendment to the PHA plan is not required. Specifically, PHAs with written policies not allowing families to stay in the public housing program if their income exceeded 80% of AMI will need to amend their policies. If a significant amendment to the PHA plan is required, the PHA should immediately take steps to comply with the significant amendment process to effectuate the policy change in their PHA plan and ACOP by June 14th, 2023. All PHAs must have effective over-income policies consistent with 24 CFR Part 960-507. Again, this date has been set at June 14th, 2023. As a reminder, HUD provided prior notice of the requirement to establish over-income policies through Federal Register notices beginning in 2018.
There are no exceptions to the income limitation on public housing tenancy. However, a PHA that owns or operates fewer than 250 public housing units may continue to lease public housing units to non-assisted over-income families in accordance with 24 CFR Part 960.503. The over-income limit does not apply to these unassisted families. For purposes of Part 960.503, the term over-income family means an individual or family that is not a low-income family at the time of initial occupancy. These families are non-assisted tenants.
PHA reporting on over-income families. The PHA must submit a report annually that specifies the number of over-income families residing in a PHA's public housing as of the end of the calendar year, and the total number of families on the waiting list for admission to public housing. The waiting list data will be submitted through the Operating Fund web portal beginning January 1st, 2024. In addition to the total number of families, PHA should be ready to provide HUD with the following data: the type of waiting list, either agency-wide, site-based, or both, whether the waiting list is open or closed, and the waiting list count by development if it is site-based. PHAs that maintain both an agency-wide waiting list and site-based waiting lists should be mindful not to duplicate households when reporting the total number of families on the public housing waiting list. In order to minimize reporting burdens, HUD will pull the income and over-income families from the existing form HUD 50058 and unit inventory data. The data pulled by HUD will include all over-income families in the 24-month grace period, families in the pre-termination period, and NPHOI families from the unit inventory data. HUD will make this data publicly available on HUD.gov.
The Inventory Management System, PIH Information Center, IMS PIC, the development submodule categorizes units by unit tenant status categories and subcategories. Per Notice PIH 2021-35, PHAs must ensure that a unit meets the substantive requirements of a subcategory for the entire period that it is in that subcategory in IMS PIC. Each subcategory corresponds to one of four categories: occupied, vacant, vacant HUD approved, and non-dwelling. At this time, PHAs will categorize units occupied by NPHOI families as non-assistant tenant over income in IMS PIC. However, a new subcategory will be created in the new system replacing IMS PIC, the Housing Information Portal, or HIP. When HIP is ready, PHAs will categorize units occupied by NPHOI families as non-public housing over income NPHOI tenant.
Pre-existing over-income families. Families who have already exceeded the 24 consecutive month grace period per the continued occupancy policy established from the 2018 Federal Register notice are not entitled to another 24-month grace period now that the rule is published. However, until the rule is effective, HUD will not enforce any requirement to terminate over-income families who exceed the over-income limit for 24 consecutive months. PHAs that adopted over-income related waivers under HUD's CARES Act notice, PIH 2021-14, must charge the alternative rent as of the effective date of the final rule or terminate the tenancy of these families in accordance with their over-income policy and federal and local laws.
We will now review some frequently asked questions on this topic. Then we will have time for your questions.
The first question is, why can't over-income families remaining in the unit paying alternative rent remain public housing program participants?
And the answer is HOTMA does not allow the unit of an over-income family to be subsidized. Therefore, the family can no longer be public housing program participants. However, the current requirements related to eligibility remain in place, and units continue to be subject to the Declaration of Trust, annual contributions contract, and the PHA's fair cloth limit.
What happens to over-income and non-public housing over-income families during a RAD conversion?
The final rule does not address how PHAs should deal with NPHY families in RAD conversions. PHAs converting public housing projects under RAD must follow the RAD statute, notices, and guidance. The PBV repositioning FAQs include guidance related to over-income families and the use of tenant protection vouchers.
Does HOTMA's over-income rule go against income mixing goals of various HUD statutes?
No, the final rule balances the need for local flexibility with meeting these new requirements. In addition, income mixing goals for the PHA are based upon families entering the program, not exiting.
May an over-income family enrolled in the Family Self-Sufficiency FSS program be allowed to finish their program if they are an NPHOI family?
Families participating in the FSS program who become over-income are also entitled to the 24 consecutive month grace period, after which they are subject to their respective PHA's over-income policy. There are no exceptions to the over-income limits for families participating in the FSS program.
Now it is time for your questions. We have been monitoring what people have sent in and will continue to take the questions in the chat. Moderators will prioritize questions that are being asked by multiple participants. If we cannot get to your questions during the time that we have today, please email hotmaquestions@hud.gov. If you have questions related to a specific resident case, we will follow up with you about those via email. We'll be prioritizing questions on today's content that will be applicable to everyone and questions asked by multiple people. The questions that are asked both during the webinar and ones that we don't get to that are asked in the chat will be compiled with answers and provided in a frequently asked questions on the HUD Exchange. We'll now turn it over to HUD staff to answer the questions.
Hopefully that was enlightening and answered some of your questions, but we appreciate all the questions that came in during the presentation as well, and we'll do our best to answer as many of them as we can in the time we have left. So the first question has to do with the earned income disregard or disallowance. And it seems as though there is some confusion about when that would go into effect, because there are multiple effective and implementation dates when it comes to 103. So those dates actually do not directly apply to the earned income disregard. So there are two other provisions of HOTMA that are being implemented right now. So sections 102 and 104, and EID falls into that segment of the rule, which will become effective January 1st of 2024. So nothing changes this year in terms of the earned income disregard. Families that are currently receiving EID will continue to receive that, and this doesn't have to change until parts 102 and 104 go into effect of January 1st of 2024. What advice can you give PHAs with respect to including HOTMA changes in our annual plans? So not every PHA will have to make changes to their annual plan. Some PHAs, well, all PHAs get to decide what constitutes a significant amendment, and if any of these changes meet the PHA's definition of a significant amendment, then they would need to take actions to update their annual plans, not just their ACOPS or public housing policy.
So the effective date of HOTMA 103 provisions is March 16th of this year.
For those that need to update their PHA plans, they have until June 14th, 2023.
Okay, so we have a question here about who would be considered an NPHOI family. And the question was, does this include Section 8 voucher families? And we want to be clear that the 103 provisions of HOTMA apply only to the public housing program. So this does not apply in any way to Section 8 voucher families. When does the 24-month period begin for those families who are currently over the new income limit? Yes.
Okay, so the 24-month period, the grace period, right, as we call that, the clock starts once a family is determined to be over income. So that could be through an annual exam, it could be through an interim. So the first time that a family is determined to be over income, that's when that 24-month grace period or clock would start.
Perfect. How will this affect an over-income public housing family in the middle of their FSS contract? So just like any other family that is determined to be over income, a family in the middle of their FSS contract would get the 24-month grace period. And so at the end of those 24 months, assuming that grace period is uninterrupted, then the over income policy selected by the PHA would need to be implemented. A family would not be exempt from the PHA's over income policy just because they have a valid FSS contract. However, they could continue to implement their FSS contract for as long as they're in the public housing program. All right, next question. What are some examples of low-income programs in which over-income households cannot participate besides resident associations? So that would include receiving a utility allowance from the PHA. If an over-income family is staying and paying the alternative rent, they are no longer public housing program participants, so they would not be entitled to a utility allowance, and they could not be part of resident associations. Anything else?
No, I think that's it. Just the distinction between, right, over income families, right, who are within their 24-month grace period versus non-public housing over income families. So as Renita just mentioned, right, like non-public housing over income families, you know, wouldn't be able to participate in resident associations or resident councils. They wouldn't get a utility allowance. They wouldn't be subject to the community service and self-sufficiency requirement. The PHA could, if they wanted to, provide or allow them to have or take part in a grievance process. But that's again at the discretion of the PHA. But generally, a non-public housing over income family, right, like is no longer a public housing participant. So they would not be able to participate, excuse me, or be subject to you know, public housing requirements.
Exactly. So the next question we see here, why would an over-income tenant be allowed to stay in public housing when the unit could be used for someone else in need of assisted housing? So this is simply a matter of what the statute allows for. The PHA does have the discretion in terms of which over-income policy that they would choose, and they would choose whatever made the most sense for their jurisdiction. So in some cases, PHAs will choose a policy where once a family receives their 24-month grace period, they will be terminated within 6 months, or they will be given the option to stay and pay the alternative rent. And even in those cases, the family will have a choice of whether or not to stay and pay that higher rent or to find housing for themselves on the private market. Okay, HOTMA says over-income families must pay income-based rent flat rent, or mixed family rent if that applies? Can over-income families pay fair market rent or just the 3 previously listed rents? Okay, so I think we'll use this question as an opportunity to clarify what the alternative rent is. So this, of course, has to do with where the family is in their grace period. So if a family is in the 24-month grace period, they are still public housing program participants, and they continue to pay their choice of rent, be that income-based rent, flat rent, or mixed rent, prorated rent, sorry, in the case of mixed families. Once a family exceeds the 24-month grace period and the PHA policy allows for them to stay and pay, they must pay the alternative rent. The alternative rent is not necessarily the fair market rent. The alternative rent is the higher of the fair market rent for a unit of that size in the area or the HUD subsidy for the unit. And the PHA must make that alternative rent whichever is higher. So now that the rule has been published and we are in the process of putting out guidance around the over-income provisions, HUD will also be publishing a per unit subsidy report that will be available on the HUD website. The PHAs that choose to allow over-income families to stay and pay the alternative rent, they must go to that report and compare it to the FMR for their area, and whichever is higher, be it the HUD subsidy or the FMR, that will be the alternative rent. So next question. When a family becomes NPHOI, do all public housing policies still apply to them? No. Once a family is a non-public housing over-income family, they are no longer public housing program participants. And so no, not all public housing policies still apply to them. The minimum requirements for these families are listed in 960.509, which have to do with the lease for non-public housing over-income families. Those families will not need to provide annual income re-exams to the PHA. They will no longer need to abide by the community service and self-sufficiency requirements, just to name a few things. The grievance procedure, that is something that is at the discretion of the PHA. That is not something that they necessarily have to extend to non-public housing over-income families, but that is again a matter of PHA discretion. And I think there was one more thing. Oh yes, the utility allowance, they would not be eligible for that. Okay, next question. So there was some confusion around the demo of how to calculate the over-income limit. So the over-income limit is determined by taking the very low income limit for a particular family size and multiplying that amount by 2.4. It is not 1.2. The VLI is already 50% of the area median income. So when you multiply the VLI by 2.4, it works out to 120% of AMI. And so that is the way to determine the over-income limit. Yes, and it should be noted that the VLI is different depending on the number of persons in the family. So in the demo, the example was of a 4-person family. So if someone was coming in for an annual examination or an interim, the PHA would take that amount and multiply it by 2.4, and that is how they would determine the over-income limit for the family. So if the family's annual income is above that amount, then they would be considered over income, and the 24-month grace period would begin at that point. Okay, what are the differences between the normal public housing lease and the NPHOI lease?
Okay, so you're looking at me. Okay, so there are a couple of differences. I'm not going to remember them all. Full transparency. The required provisions are spelled out in the reg in a new section 960.509. Some of them have been adapted from 966.4, which you are, all I'm sure very familiar with. So there are quite a few similarities, but there are some differences. And so I would just advise you to just ensure that your leases contain the required provisions that are spelled out in 960.509. We also have, to complement this presentation and also to assist and support, implementation of these new provisions, there is a sample lease that now CAB put together that will be available on HUD Exchange, along with these slides, as well as sample notices that you can adapt and customize that contain the required information that's contained in the new regulations. So yeah, anything you want to add?
Yes, so the lease term is also something that is different between a public housing lease and a non-public housing over income lease. The public housing lease is automatically a 12-month lease, whereas the NPHOI lease, the term is determined by the PHA. So they have the option of offering an NPHOI family a month-to-month lease or a lease that is less than 12 months, and that is at the discretion of the PHA. So next question. Does the NPOI, did I say that right? NPHOI person have the right to ask for an interim in the event they lose their job? No, they do not. An NPHOI family or household they are no longer public housing program participants. So in the event that they lose their job, unfortunately, they cannot request an interim. An interim is something only public housing program participants can request. There is a discretionary preference that PHAs can choose to apply, where they could provide an NPHOI family additional preferences if they need to reapply for the public housing program. And that is something that is at the discretion of the PHA. Do MTW agencies have any regulatory flexibilities with these changes for their existing activities? So for example, biannual reexaminations, etc. Can they propose new MTW activities regarding these HOTMA changes? So while MTW agencies do not have any regulatory flexibilities, they do have an operations notice that does extend the 2-year grace period from 2 years, 24 months to 3 years. And the MTW program also allows PHAs to request a waiver, which must be approved by HUD and could potentially extend the grace period further. So those are options that you would present in your MTW plan and would need to be approved by HUD. But generally speaking, there are no exceptions.
Right. So that is to say that MTW agencies have to have an over income policy, but there are some flexibilities in terms of the grace period and the timeline.
Okay, another question. So if you are less than 250 public housing units, none of this pertains to us. No, that is not correct. So there is a provision in 960 for PHAs with 250 units or less. So this is a provision for families that are above the low income limit at initial admission. However, if you have a public housing family that entered as a low-income family and has since become over-income, these provisions would apply. So you would still need to have an over-income policy and begin a grace period and have a policy of what would happen at the end of that grace period, whether that family would be terminated within 6 months or pay the non-public housing over-income, or sorry, the alternative rent. So I understand the over-income. However, do you take deductions into consideration? If you have a resident that is over-income, but their medical deductions are still high, would they be a credit renter? Would they still be over-income? Okay, so this is a good opportunity to point out a change in guidance between the prior notice that HUD put out on the over-income provision. So that was notice 2019-11. And in that notice, the guidance was for PHAs to compare the family's adjusted income to the over-income limit. So the new upcoming notice will clarify that the over-income limit needs to be compared to the family's annual income, not taking any deductions into consideration. Anything else to add to that?
Yeah, so that was a clarification that we needed to make. And so we, for determinations that have already been made, under our current guidance using adjusted income, PHAs you won't need to go back and kind of recalculate whether or not the family exceeded or other families exceeded the limit, right? So the annual using annual income will only apply going forward. You won't have to, kind of do any retroactive calculations. That's all I did.
Yes. Oh boy. Okay. So if there is a tenant asking someone to move in with them that would make them an over-income family immediately, can we deny the move-in of the additional member? That's a good question. So the PHA would evaluate the eligibility of that tenant as they normally would, and they could, of course, make the family aware that adding this member would make the family over income. But it would be at the discretion of the family as long as the individual was eligible. That would not be grounds to deny them from moving in or requesting that an additional member be added to the family. Okay, so we are at 3 o'clock. So I think we're going to wrap up. Any questions that we didn't have a chance to get to today, please send them to hotmaquestions@hud.gov. We want to thank you for your time, and I'm going to turn it back over to Phil.
Thank you, everyone, for participating. I want to remind you to register for the 2 upcoming trainings on changes related to income and assets, tentatively scheduled for May 9th and May 16th. I also want to remind you to go to the HUD Exchange HOTMA Income and Assets Training Series web pages. There, you will find related resources for the trainings, including recordings of each of the live trainings and the slide decks. For this training, you will find Section 103 Over Income Limits for Public Housing Families fact sheet, sample NPHOI lease, and over income notices, and shortly, the training recording and slides from today, as well as a new FAQ based on questions from the live webinar. Recordings of the live trainings and resources related to implementation of HOTMA Sections 102 and 104 Income and Assets will also be available after those trainings. All registered participants will receive a follow-up email with a link to these resources, which are available on the HUD Exchange.
Please remember to sign up and attend the next training. That training will be part 1 of HOTMA sections 102 and 104, income and assets, and will include information related to income inclusions and exclusions, the earned income disregard, income from assets, deductions, student financial assistance, and hardship exemptions for certain expenses. We look forward to seeing you then. In the meantime, you can send any follow-up questions on this training to hotmaquestions@hud.gov. Thanks for participating.